Hi Vandana, thank you so much for speaking to the Indian Weekender once again.
My pleasure.
This week, I wanted to ask you about the partnership visas and how do New Zealand residents or people who are on work visas get their partners over. So first thing first, how does Immigration New Zealand define who is a partner?
Okay, now that's a very good question. Thanks for asking. We get some questions on similar lines. So in the instructions, partnership is with somebody who is in a genuine relationship, a relationship which is a genuine, which is stable, which is most likely to be endured, and the couple has been living together in that genuine relationship. So that's how immigration considers partnership.
So is there a time frame attached to it that you have to be living, let's say 6 months or 1 year before the immigration would consider you as acceptable partners?
Okay. So when somebody is applying for a partnership-based residence visa, that is when there is a limit, at least they should have been living together for 12 months period. For temporary applications, for visitor work, there is no minimum living together requirement. However, we see clients asking this question every time. They feel that 3 months, 6 months is something they should live together. However, the instructions for temporary visa have no minimum living together requirement. It's just that the visa officer, with whatever are the documents presented on the application, should be able to be convinced that this relationship is genuine, that this is most likely to be endured.
Is it true that people here actually quit their jobs and go to India to live with their partners just to prove that, they're legally living together?
It's sad, but yes, a lot of, and especially with our cultures, there are a lot of marriages which are arranged marriages, which are culturally arranged by family members. So the couple hasn't really met each other for long. So there's no longer inception development of the relationship. And then I don't know how it kind of got spread that at least 3 months they have to be living together or more for our partners to be supporting. They leave their job and go, or if they are able to work from home, that's still okay. I would just like to convey that's not required. If somebody is in a genuine relationship or the family's planned a relationship, definitely the family would have seen so many factors. The family would have made sure that it's done in a way that it will definitely endure. And these things could be explained to immigration upfront. There could be options such as a visitor visa. There could be options as a partnership-based visitor visas. And immigration understands that if the living together is not long enough, but there are enough documents in the application which confirm that the couple is in genuine relationship. The intent behind getting into that relationship is genuine.
So what kind of documents would these be?
Okay, so these could be, how was the match arranged? If let's say a scenario where couple have not met. So now assume, let's see, and there would be an officer who's processing this application in Hamilton. So that officer could be of any ethnic background. It could be let's say a Japanese assessing. So for them, very strange for them to understand unless it is provided on documents that how did it happen? This person just went back and got married and they've never met before. So for them, it's very strange. Unless the cultural background, the cultural context is explained in the application itself. So something like what are the cultural similarities, what are the factors families would have thought of when arranging, how did they communicate, were the couple in touch on messages, or how did the match really happen? So there would be a cultural context to the families arranging that match. And as an advisor, we make sure that we put that on paper. We ask for all the documentary evidence so that the officer, if the officer has a similar cultural background, they would definitely understand. But what if that officer is not an Indian and that person doesn't have has limited cultural experiences? So then it becomes really important for an advisor to make sure that the application has all that explanation on what happens in that culture, this is what the norm is, this is how families arrange. And despite the couple not knowing each other for a very long time, this relationship is most likely to be endured. So that's what they have to be convinced on.
Okay. And for people who are already here, either on a work visa or they have residency or they're citizen, what options do they have to get their partners over? And can their partners work here?
Okay, so let's break down into 2-3 parts. So let's talk about partners of citizens or residents. So partners of citizens or residents definitely can apply for or bring the partners in here. One good thing is New Zealand really believes in families' unification. So they would never want a scenario where genuine couples are separated. So be it partners of citizens or work visa holders or student visa holders even. So anybody who's in a genuine relationship, let's say citizen, can support the partner for visitor visa, can support the partner for work visa. And if the couple have been living together for 12 months, can even support the partner for residence visa. So these are the options. Partners of work visa holders, there have been few changes recently. If the partner is working if the partner is working in an occupation which is in green list, or they are being paid more than twice the median wage rate, they can support partners for work visa with open work conditions. For other work visa holders where they are being paid more than the median wage rate, but the role is not in the green list, the partners would still get work visa, but the partners will have some conditions on their work visa, that they can only work for accredited employer, they can only work on the median wage and things like that. Somebody who's not getting a median wage rate can still bring the partners to New Zealand, and then the partner would be eligible to come on a partnership-based visitor visa. So the important thing is the family as a unit gets to stay together here in New Zealand, be it on visitor or work. Similarly, student visa holders. So if somebody is studying a master's program, if somebody is studying a graduate diploma or a level 7 program which is in the green list, can support the partners for work visa. If somebody is studying a or even a PhD, definitely partners can come on work visa. If somebody is studying a program which is less than master's, and the role is and the study is not in the green list, partners can still be together on a visitor visa. So just want to spread this message to all around, that family as a unit together is very important for immigration, and we're really happy about it. It could be on a visitor, it could be on a work, it could be on residence when the time comes. The migrants or the citizens don't have to think that they have to do anything different, anything special just for immigration. Like you said, leaving the job and going. They don't really need to do anything if their relationship is genuine, and if they are able to prove that on documents, whether it's a new relationship, whether they've been in that relationship for long enough, immigration will consider and give whatever is the option available.
So you deal with applicants coming to you with their problems related to partnership visas. What are the most common issues that you encounter?
Okay. Most common the problems that we encounter is they may be living together or for a shorter period or a longer period, but the documents don't reflect that. Sometimes within our culture, there are some specifics, like they would be staying with their family, with the parents' house. There could be the girl or the boy would not have changed their pre-marriage address. The Aadhaars could reflect different addresses. The passports could reflect different addresses. The bank accounts are not changed, so that could reflect. So even if the couple is in genuine relationship and they're living together, if these documents are presented to the officer kind of gets a contradictory information because it doesn't convey that way. That's one common thing. So then it becomes, as an advisor, our responsibility to either see if anything could be explained or reasons behind why. So if the passports have been made, how long does it take for the passports to be rectified, or things like that. So if the couple is living with families, and they definitely will not have utility bills in their name. So what happens is there is that long checklist on the immigration website which says these documents are accepted for living together. It would have tenancy agreement, it will have utility bills and things like that. And if somebody is living in the joint family setting or in our country, they definitely will not have those things. And in no way should they even try to get that done, because that won't be genuine in itself. So then it becomes important to explain what is a joint family setup, or how couples live together. They may not have utility bills because if they are living with parents, they are not required to pay that, and the bill will always come in the name of the person whose the house the name is in. So basically, whatever be the documents, if they are contradicting what the instructions require, then we need to explain why, so that the immigration officer doesn't view it as a reflection of genuine relationship. Another very common question is that there would be a longer relationship, but a longer separation as well. So sometimes somebody would get married, come for his work commitments, and then again go on the holidays and be together. One of the partner would have some work commitments back home. So somebody's on the work visa, but they've been if somebody's applying for a student visa, but they've been living separately for their commitment. So again, that becomes a challenge. So and we get clients who are really not happy about it. So they would say, hey, see, my partner just got married and they did not give much documents to immigration and their visa came quite quickly, but I've been married for 4 years, and look at the kind of questions immigration is asking me on genuineness or more documents. So our answers in that situation is, see, if it's a new relationship, immigration accepts that there wouldn't be anything. But if it's a longer relationship and if you've not been together, then definitely you need to give more to explain what have been the reasons for separation, your work commitments or partner's work commitments, and so that immigration doesn't feel that the separation is due to the relationship. The separation is due to some commitments, on both ends. And then you've maintained your relationship during the separation period, you've got communication records, and then you've got financial interdependence, the family supporting and things like that. Another big challenge is that a lot of time people would talk on the phone, not have much messages in the to share, and then or the messages would be they would submit those message records, but when the officers looks at the message records, they really can't understand who is talking to whom, because the names would be in their own nicknames or whatever. So for the officer, those documentary evidence hold not much value. So it doesn't really matter much how many documents we are giving in the application. Really matters on what are the quality of the documents that are being submitted. Is the officer able to be satisfied of anything when they look at those documents? That's another thing that the clients find challenging on gathering those relevant documents.
That's really useful. As always, thank you for your time speaking with us and giving us your views on this. Thanks.
Most welcome. Thank you so much.